Welcome to SCOTUScast, Extortion, Conspiracy, and Property Edition. Thank you for tuning in. On March 2, 2016, the Supreme Court decided Ocasio v. United States. Former police officer Samuel Ocasio challenged his conviction under the Hobbs Act for conspiracy to commit extortion, which arose from an alleged kickback scheme under which police officers funneled wrecked automobiles to a particular repair shop in exchange for monetary payments. He was charged with obtaining money from the shop owners under color of official right, and of conspiring to violate the Hobbs Act. The district court rejected Ocasio's argument that Hobbs Act conspiracy requires proof that the alleged conspirators agreed to obtain property from someone outside the conspiracy. He was convicted on all counts, and the U.S. Court of Appeals for the Fourth Circuit affirmed the convictions. The question before the Supreme Court was whether a conspiracy to commit extortion requires that the conspirators agree to obtain property from someone outside the conspiracy. By a vote of 5-3, the Supreme Court affirmed the judgment of the Fourth Circuit. Justice Alito delivered the opinion of the court, which held that a defendant may be convicted of conspiring to violate the Hobbs Act based on proof that he reached an agreement with the owner of the property in question to obtain that property under color of official right. Justice Alito's opinion was joined by Justices Kennedy, Ginsburg, Breyer, and Kagan. Justice Breyer filed a concurring opinion. Justice Thomas filed a dissenting opinion. Justice Sotomayor filed a dissenting opinion in which Chief Justice Roberts joined. To discuss the case, we have Timothy O'Toole, who is a lawyer at Miller Chevalier. As always, the Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker. And now, Mr. O'Toole.
In Ocasio, the Supreme Court faced a question about the scope of the federal conspiracy law and how that conspiracy law applied in the context of a Hobbs Act charge, where the defendant was charged, he's a Baltimore police officer. He had been charged with violating the Hobbs Act by getting together with the owners of some local car repair shops. And when the police officer would arrive on the scene of an accident, the police officer would then refer the people who had been in the accident to this car repair shop for repairs. And in exchange, the car repair shop owners would provide the police officers with what are called in federal law kickbacks. That is, they would provide payments to the officer for making the referral. And those payments are prohibited by a variety of federal criminal law provisions. And one of those provisions is potentially the Hobbs Act, which is a law that was designed to prevent extortion by public officials of individuals in order to obtain money. That is, if a public official said, I'll give you a permit, but in order to get the permit, you're going to have to buy me tickets to an Orioles game, or you're going to have to give me a certain amount of money, that would be the sort of extortion that the Hobbs Act was aimed directly at preventing. But over the years, and in particular in a case called Evans versus United States, the Supreme Court ruled that the Hobbs Act also prohibits what looks a lot more like a bribe or a kickback. That is, when the Hobbs Act also applies in a situation where there's no extortion going on, but instead what you've got is kind of an agreement, as in the Ocasio case, between the public official, the police officer, and the shop owner, where they got together and they actually agreed without any coercion to an exchange in which the public official would use his official actions to benefit the shop owner, and the shop owner in exchange would give the public official a thing of value. And so that's the context in which Ocasio arose. And the specific question in Ocasio was whether or not, in order to be convicted of not only a Hobbs Act charge, but conspiracy to violate the Hobbs Act, somebody within the group had to have obtained the property of somebody of another, which is what the statute said. And what the defendant in Ocasio argued is that somebody in the group had to obtain property from someone outside the group. That is, it couldn't just be the two people who agreed to exchange official acts for things of value. It had to be somebody's property that was another, outside the scope of the conspiracy. The government argued that it was enough that the public official obtained the property of another person, even if that person was technically part of the original exchange. Now, I think when we talked earlier, right after argument, I went through kind of some of the bigger issues that were at stake in the Ocasio case. One of them is that, and you can see from these facts, that essentially, that sort of argument by the government, if accepted, turns one crime into two, because in every case like Ocasio, if a public official and another person agree that they're going to exchange an official act for things of value, that agreement is also the premise of a conspiracy charge as well. And so instead of having one crime through this agreement, you're creating two crimes through this agreement, and that creates two related problems. One is that by having multiple charges for the same conduct, you increase the power of prosecutors because they can charge you twice, which means that they can increase sentences, which means that they can increase the pressure for you to plead, and which means that they can gain a sort of leverage over the criminal justice process that they otherwise wouldn't have. And then I think that the third issue is that we talked about a little bit was that by getting that leverage, they also are able to bring conspiracy charges, which are an easier charge to prove, in part because the conspiracy statute creates different rules of evidence that apply in conspiracy cases, namely that all sorts of evidence that otherwise would be considered unreliable by the criminal justice process and excluded from consideration comes in a conspiracy case. And so by construing this statute to allow conspiracy charges to be brought for the same underlying conduct as Hobbs Act charges, it creates those sorts of potential problems. And so those were all of the issues that were kind of percolating against the backdrop of Ocasio. And so what did the Supreme Court do? Well, by a vote of 6-3, basically, because there was one concurrence, but by a vote of 6-3, the court ruled that the government could bring on these facts not only a conspiracy charge, but also could bring a Hobbs Act charge. And so the Hobbs Act, even though the Hobbs Act said that you had to take the property of another, the Supreme Court ruled that it was enough that one member of the group had property being taken. And so because the car repair shop owner's property was taken, even though it was consensual, the police officers were taking the property of another, and the group had conspired to take the property of another they said that it doesn't matter that not every member of the group could have committed the act as long as one member of the group could commit the act. And so even though it was impossible for the car owners to take property of another, and so they couldn't actually have taken the property of another and conspired to do it, it was enough that the police officers were able to do it. So that was the holding of the majority. And the basic reason for their holding was that what they viewed as longstanding principles of conspiracy law allowed for a result in this sort of situation. One, because not every member of the conspiracy had to be capable of committing the underlying offense, and two, because there were a couple of cases brought under a different federal statute, a statute called the Mann Act, in which people who had been the victims of the crime, basically, as arguably the shop owners were here, had also been found to be able to conspire to commit the same crime that they were the victim of. So that's kind of the basis of the Supreme Court's holding, or at least the majority's holding. Now, Justice Breyer concurred in the result, and his concurrence is interesting because it kind of dovetails with Justice Thomas's dissent. And so what Justice Breyer said was, look, the problem here really was that we misconstrued the Hobbs Act originally. The Hobbs Act applies only to extortion. And if we had limited the Hobbs Act to applying only to extortion, we would never have the situation that we had here where there was an actual consensual agreement, which is not only the basis for a Hobbs Act violation, but a basis for a conspiracy. And that's the real problem here. That's why you have this overlapping charges and the increase in prosecutorial power. And I think we ultimately misconstrued the Hobbs Act. And if that were in front of me, I would construe the Hobbs Act as only applying to extortion. That is a situation where the public official demands something under color of official right, and that at most the private citizen grudgingly agrees to it. And so that was a big mistake. If that were in front of me, I would vote to overrule that case, but it's not in front of me because everybody agrees that that case was rightly decided, at least for the purposes of the Ocasio case. Given that, I concur in the majority opinion. Justice Thomas dissented, and his dissent was very similar. And what Justice Thomas said was, I agree with Justice Breyer that this Evans case was a big mistake. That is, we never should have construed the Hobbs Act to include an element of bribery or kickbacks. That those are separate statutes, and those statutes govern their own conduct. And so basically, where Justice Thomas differed from Justice Breyer was that Justice Thomas then said that given that it was bad enough that we messed up in Evans by construing the Hobbs Act too broadly, but I think then we construe the Conspiracy Act too broadly too, and we compound the error. And so even though I understand that what the majority says is correct if you follow the logic of Evans, I think Evans was wrongly decided, and I wouldn't go any further than just saying that, than basically saying we stop at Evans and we don't compound the problem by construing the Conspiracy Act too broadly. So that was Justice Thomas's dissent, but Justice Sotomayor also dissented, and she was joined by the Chief Justice. And I think, well, Justice Breyer and Justice Thomas kind of got at this issue about the Evans case, which really was a kind of a not the underlying fundamental conspiracy issue, but a little bit of a part of it. Justice Sotomayor's dissent went straight after the majority's expansion of the conspiracy law. And I think that was probably, in my view, the most interesting debate in this case, is that you have on the one side the majority talking about why their decision is appropriate because it's grounded in, I think they call it, well-established principles of conspiracy law. And then you have the dissent really taking those principles on and saying, one, they're not very well established, and that was really part of the dissent. But two, they also violate this principle that we're really supposed to try and construe this conspiracy statutes narrowly, and we're not supposed to expand them unnecessarily. And I think part of the reason that I thought that part of the dissent was quite interesting was because I do think, and I said this in the earlier podcast, that conspiracy law has been just almost granted an unlimited license by the Supreme Court to expand over the years, and which is a little bit odd because there really was no conspiracy at the time of the framing. And so, conspiracy law actually has a much less of a historical grounding than many of the other criminal laws. But it has been expanded dramatically since the Civil War by the court, and in a way that is very different from some of the other laws because, as we discussed, the rules that apply in conspiracy trials actually are much more loose than the rules that apply when in other criminal trials. And so what I think is really interesting about Justice Sotomayor's dissent, and also it's interesting that the Chief Justice joined it, is that it really takes on this notion of any sort of well-established common law principles of conspiracy other than this principle that you're supposed to construe the conspiracy statutes narrowly, which is not one that has been applied all that often by the court. But I think that it's interesting because the dissent then takes on all the problems that a broad construction of the conspiracy statute creates. And I think this dissent is really, there's been a lot of recognition of these problems in the criticism, in the legal criticism by legal scholars, both on the right and on the left. But there hasn't been a lot of recognition by anybody on the Supreme Court as to kind of what a mess conspiracy law is and how kind of there aren't these grounded, principled arguments for expanding the conspiracy law. It's just basically expanded without virtually any limits. And I think this dissent is one of the first times that I've seen in recent Supreme Court jurisprudence where some members of the court seem to be saying enough is enough and talking about the sorts of problems that the double counting problems that we talked about, because the conspiracy charges here are almost always going to result from a Hobbs Act violation because the consent that you need to create the Hobbs Act violation is the same sort of agreement that will give rise to conspiracy charge, and how that vastly expands the power of prosecutors, how it disrupts a pretty carefully crafted federal public corruption scheme, and then also how it really impinges upon federalism. And Justice Thomas's dissent talked about that as well. I mean, I think both Justice Thomas and Justice Sotomayor's dissent were very concerned about the way that the vast expansion of the conspiracy laws has affected the power between federal and state officials. And this case, the Ocasio case, is a great example of that because, what you have is a federal prosecution for what is clearly, at most, local corruption by some police officers in the community. And so you've got a federal prosecution that has been made out of it, and it's been made because of the expansive kind of reach of the federal laws and the way that they've been construed by the Supreme Court in the last 40 years. And so I think, at the end of the day, to me, what was interesting about Ocasio was not the majority opinion. The majority opinion did what the Supreme Court has done a lot of over the last 40 years, which is kind of broadly interpret the conspiracy laws using kind of precedent whose application is questionable to the case, but that seems to be good enough for government work. That's not anything new. I think what's new is the fact that there were three pretty powerful dissenters to this who seem to be suggesting that there may be a point where the court is going to say, enough is enough and start to rein in the conspiracy laws. And in my view, that's a very interesting development and one worth watching.
Thank you for listening to this episode of SCOTUScast. For more episodes of SCOTUScast, as well as audio and video of past Federalist Society events, please visit our website at www.federalistsociety.org/multimedia.